We are live. Hey, good morning. We're back in Senate Judiciary on March 11th. We have S298 in front of us. We don't have it in our possessions, but this, I would have to take a look at it, or for our committee to take a look at it, because there are some criminal offenses in it, as well as some private right of action provisions, and we just wanted to take a look and make sure there's nothing that's changed necessarily. So we have Legend Counsel here with us, and the floor is yours.
Thank you very much for having me, Chair. And for the record, my name is Tim Devlin, Legislative Counsel. So if you have before you a strike all amendment to 298, that's a over from the Senate Government Committee. This is an act relating to creating the Vermont Voting Rights Act. And let's see, there are 4 criminal sanctions here beginning on page 3 is where we have them housed in 17 VSA, chapter 35. 17 is the title where we have all the election laws. And 35 is where we have existing offenses against the purity of election. Some of those are criminal in existing law. Maybe 2 or 3, there's 10 or 15 of them, I think. And right now, the current law primarily it's oriented towards election officials and misconduct by them, as well as voters and voter fraud. So this will be introducing the idea of third-party interaction, although it certainly will also see some conduct of some elected officials and some voters and frauds and cities. So now we're oriented. We'll turn to page 4 of the bill, where we begin in earnest with to be added first offense in section 1934, interference with voting, and version would be fine for me just to read right through. An election officer or a person acting under color of law shall not intentionally, 1, refuse to permit or fail to permit a qualified voter or vote. 2, refuse or fail to tabulate, count, or report the vote of a qualified voter. 3, change a ballot of a voter to prevent the voter from voting as the voter desires. And then we have the felonies here, and this is contains one type of that I will just notice it. Correct. So B1 states a person who violates subdivision 1 is an A1 or A2 if you're refusing to present insult by vote or refusing to tabulate those ones. Shall be subject to a civil penalty of not more than $1,000 for each affected voter. B2 states a person who violates subdivision is A3, strike the A4 or of the section. That is election officer or person operating law who changes the ballot. They shall be imprisoned not more than 6 months or fined not more than $1,000 or both, which affected the voter. And then C, this section applies to any election and to any method used by a political party for selection of its nominees and or selection of delegates, conventions, and meetings. So, sorry,
is B2 also civil? Doesn't
no, once we
what is that?
include jail time,
That will automatically be. Yeah. Okay.
So yes, the conduct described in A1 and 2 shall be civil penalties.
Yeah.
And then in A3 will be criminal. Sorry.
Yes, line 4.
Yes.
Can you give me the bill's definition of a qualified voter?
Qualified voter will be detailed elsewhere in Title 17. So typically, just off the top of my head, a qualified voter will be somebody who is registered, who then looking into what requirements for registration would have to be, these are state constitutional issues of age, of residency, and of citizenship. Or the excluding all elections, excluding the few localities where we non-citizen voting.
That was my next question. Okay, so how does this pertain to those? The overall, you want to speak?
Yep, in those municipalities where there is non-citizen voting, it would certainly apply to them, as we see, it's qualified through C here, which is basically any election. And so if, they have the separate checklist, person who's qualified non-citizen voter, I mean, they would still be qualified to vote for certain elections, just not all elections. So they would, these kind of, sanctioned conduct would apply, to non-citizen voting, those elections. Only the extent for, they can, they're qualified to vote in those ones with the others. So a big circular there, but. So, happy to unpack it with that for $74.
Well, we're just doing
Oh, sure.
a flyby here, but the sections that pertain to us, obviously, the bill, we'll have to read this, obviously, it's entirely here.
Yes.
But there's a little section of the apply to us that's gonna be.
Senator Murphy.
This is jumping ahead, but on the civil cause of action, can you just outline what the committee's thinking is about the need for that?
Sure. Can't really speak to intent necessarily, if I can describe the mechanism and perhaps effects. And so essentially we have a few different mechanisms of enforcement. Criminal, I'm sure everybody here is aware that will be enforced by either the state's attorney or a state's attorney or an attorney general's office. This allows a third avenue of enforcement in civil context to be provided by basically any voter who is agreed. If there's two parts of civil, two statutes be added to make a civil cause of action. One is 2023, so intimidation of voters. So if somebody is, the voter is say, intimidated for a vote right now, they can go to court and seek redress, or really, should say, redress in the form of injunction as a restraining order or any other order against the intimidating persons preventing them exercising their right to vote.
Can I ask, prior to this going into effect, if it does, could they not launch a civil suit now?
Let's see. It may depend on the election. So we have certainly. Well, I shouldn't say. It'll depend on the nature of the intimidation. If it is criminal, like criminal threatening or something like that, there's already issues under state statute for police prosecutors get involved there. If it's something more based on civil rights, in a federal context, federal elections, there are certain cases and protections under various aspects of federal law, I think some parts of the Federal National Voting Rights Act. If it's,
I guess where I'm going with this is I'm wondering, it seemed like whoever called for the drafting of the bill believes that there's an area not being covered that could be covered through these civil suits. But as always, you're trying to game out what the potential for misuse of private rights of action would be. And the language is really broad when it comes to applies to any election and to any method used by selection for its nominees. I'm thinking in other states, I haven't read about it so much here, but you have nominating caucuses that devolve into chaos and people are punching each other. And over the last 10 years, this has become kind of common around the country. And I'm wondering, in that context, if we provide a civil right of action, if we don't get a flurry of lawsuits, people suing and countersuing each other.
I can say that the private right of action, civil cause of action here, by the individuals voters is limited to just two contexts. So one, where there's intimidation of voters, not interference with voters, although if intimidation is interference with voters, it's somewhat overlapped there. Then the second one would be communication of false information to voters.
I guess I'm thinking of the intimidation piece, like, you know, in any event, we're just doing a drive-by or, when I just drive-by.
The drive through or whatever that means. So,
So, but that's a question that I've had about this is, and maybe it's from the drafter, or the sponsor, why this was necessary. Or you're on, is it your bill?
I mean, I'm a co-sponsor on the bill. It's not my bill. It's Senator White. That was the original drafter, although it's gone through quite a few changes since originally introduced.
It was introduced by Senator Ron and Sam.
Oh, okay.
And then the amendment. Up this year.
And I think some of the concern is that right now the federal voting right that gives some of this right to civil action is in jeopardy of being overturned. And so a lot of this was really meant to codify sort of current practice under the Federal Voting Rights Act into our Vermont state law to provide those same protections that currently exist, but may not.
Right.
And so that was really the sort of impetus of this, but again, it's gotten pared down quite significantly from its originally introduced state.
Okay.
So it's yes, it appears as though there's no discretion in this where it says the person who violates this subsection of it shall, not may, but shall be, same under the line 11. And my question is for the civil portion of this, what's the enforcement mechanism?
All right, and which section are you referring to? Sorry, sir.
On page 4,
Page 4. Okay.
lines 9,
Yes.
and then again on lines 11.
Okay.
There's no, it says shall, there's no may, there's no discretion there whatsoever. And if there is no discretion from the civil portion of this, who is the enforcement, what's the enforcement mechanism?
Sure. So speaking to the shall, I ran this by our judiciary team, and it wasn't flagged as really kind of any concern about undermining prosecutorial discretion or anything like that. Turning to the idea of was the question who's enforcing the civil aspect, or is there a private cause of action in this?
Do we have like polling police here going to enforce this? Who's enforcing this?
Right. So, like any other crime, it would predate on, I presume, a police investigation. Perhaps I think the AG's office could investigate independently, or the civil aspect. Actually, the person. Page prior to this gets into a different type of civil action that Chair Keller read together with that. But as far as exactly implementation on the ground, I would probably defer to their state's attorney or the attorney general's office. That's exactly how this would be important. For the mission statements, they don't speak about. Oh, right.
I guess the first thing I can see of somewhat of investigation on the criminal aspect of this, but not the civil aspect of law enforcement. Anyways, that being said, thank you.
any other questions, or did you want to carry on? Sure. Thanks.
So next we have intimidation of election officers. So the bottom of page 4, going to page 5. A person shall not intentionally by bribery, intimidation, threats, coercion, or other means in violation of the selection law, hinder or prevent or attempt to hinder or prevent an election officer in a polling place or from holding an election. B. The person who violates this statute shall be imprisoned not more than 2 years and fined not more than $2,000 or more. So, yes. Going for any questions? Okay. Moving on to the next offense and 2023. Intimidation of voter. and semicolon, civil cause of action. So, A, a person shall not intentionally intimidate, threaten, or coerce, or intentionally attempt to intimidate, threaten, or coerce, one, any other person given person to on the ballot. Two, a voter shall intimidate a voter to deter or prevent the voter from voting at all. B, a person who violates the section shall be imprisoned not more than 2 years or fined not more than $2,000. Now we move on to the right action.
Sorry, is this, so I'm thinking about the, election day. Candidates normally stand at front of the polling place, and I know, we're not after others, but trying to make conversation. Was there any talk in committee about that? Intimidating voters? Because I do hear from folks like, I hate walking up and having all those people standing there, and it just makes me feel weird walking through all the candidates. Is that an area where that person could then feel intimidated?
This will be, it will require more than merely intimidated. This will be underpinned by the truth threats doctrine, which sure somebody at some point probably come through here and say, but just to kind of reiterate, it's all based in a Supreme Court case called County v. Colorado, which explored this idea of, how threatening does conduct actually have to be before it loses its First Amendment protections. So, as a starting place, First Amendment will protect your right to free speech, and what you can say, especially in the context of political speech. There's surprisingly regulate that, but not all speech is protected. So we have things like defamation, fraud, obscenity, and truth threats is another one of those categories. And in essence, it just kind of pull from the case here some of the useful definition that truth threats are serious expressions conveying to the speaker, conveying that a speaker needs to commit an act of unlawful violence. The existence of the threat depends not only on the mental state of the author, but on the statement. That's what the statement conveys to the person on the other end. When the statement is understood as a true threat, all harms that have long-range threats can eventually follow. And then that's to be taken also with circumvention behavior that's applied. And so here we have intentionally. The Catlin case actually put the constitutional standard at a reckless mindset. So what mindset does the perpetrator have to take into this for it to be considered non-protected? So we have the highest potential and purposefully and recklessly and negligently. So the Supreme Court said reckless, but here we're actually the bill is setting it at that higher standard. So it has to be intentional, which really means sometimes we use purposely interchangeably here, but the concept you said particularly is the term intentionally. So consciously desires a result is another way to think about that. So you have to consciously desire to intimidate, threaten people in a way where not just something that you should have known better or you just think I care, but like I'm setting out to intimidate people. So it does depend to some degree on what the recipient so it's also very relevant exactly what the mindset of the person speaking there will be, or it's not necessarily speech some sort of waving something that could be threatening. But screaming, depends on what's said, depends on how particular, we're talking about insurance threat here.
Okay. So it sounds like based on just the normal standing there with your sign, hey, thanks for coming out, that type of stuff. Yeah. Cool.
Now turning to the civil right of action here in C. So we're on line 14 of the line. In addition to the criminal penalty provided in subsection B of the section, such action shall also create a private cause of action. A voter who is intimidated, threatened, or coerced by another person violating subsection A, the section shall be entitled to act for injunctive relief, including application for a permanent or temporary injunction or hearing order of the order of such a person. The action shall be initiated in supervision of court from the Superior Court in the county in which the alleged violation occurs. A court may, in its discretion, allow private appointment of reasonable attorneys as part of the cost of the prevailing party. Then we have the section D here, those sense of possibility of election. The previous section. So there's no compensatory punitive damages here, consequence, attorney's fees, and injunctive relief. Not to say that other law or statutory courts wouldn't be available to anybody, but this strictly speaks to injunctive relief. Moving on to 20.4, communication of false information to voters. A person shall not intentionally communicate to a registered voter false information, knowing the information to be false, for the purpose of impeding the voter in exercising the right to vote. The provisions of the section shall apply to information only about the date, time, or place in the election, how to register to vote, or a voter's registration status. So that second sentence very much qualifies the first. I should just note that it's misinformation on time, place, and manner of election, or the mechanics of an election. Misinformation about those items, not protected species, similar case law on that too. It's pretty clear. B, the sanctions. Any person who violates the provisions of section A of the section shall be imprisoned not more than 6 months or fined not more than $1,000 in both. A violation is prosecuted in the Superior Court in either county in which the alleged communication is made or the county in which the communication is received. There's a difference here. This contemplates activity committed remotely. Actually, C, in addition, and here we have another divided right of action. In addition to the criminal penalty provided in subsection B of the section, violation of provisions of the section shall also create a divided right of action, and a registered voter to whom such false information is communicated shall be entitled to institute an action for effective relief, including an application for a permanent or temporary injunction, determine whether that it's such a section. And court may discretion allow any pictures. So the same language sector.
So Tim,
Yes.
do they not already have this ability or simply codifying this right of threat?
Or communication of false information, same for that statute when it comes to elections anyways. That will come to private individuals' ability to seek redress through objective reports. I don't think there's anything that I'm aware of. What's that? Yeah, okay. Oh, great. Yes, okay, great.
I just want to make sure I'm not cutting off. Any last questions? Any issues with the bill? Anybody that you folks want to hear from or suggest changes? We don't have it in our possession, but is there anything that we want to communicate to GovOps, or are we fine with the language that is shared with us?
I'm fine with it.
I'm not comfortable with it, but I'm going to ask mine here. I'm looking at the question I asked earlier in reference to shall versus may versus no discretion. But when we're doing this, and we're going to enforce this as in process. And I also have a problem with private right of actions, and it feels like I looked at here.
But I think the language regarding the shall issue a violation, I want to double check this with Flesh Council, with Eric perhaps, but pretty sure that's the standard language that we use for any, excuse me, for any violation. That, you know, you're going 90 miles an hour on the interstate, you shall get a citation for speeding. I believe that's the standard language there. Typically would be law enforcement that issues the BCBC civil ticket for that aspect. But I don't have much that I can answer regarding the private right of action aspect of it.
Yeah, I'm not even sure of using the BCBC versus the city like shall. Have to think about it.
Yeah.
Shall we say?
Okay. Well, if you want to follow up with Eric to clarify those questions, but
And I just pulled up criminal threatening, 13 VSA 1702, similar language here, a person who violates this subsection A shall be imprisoned for not more than 2 years or fined not more than $1,000. Check through, but yeah, I can double check that one example, but
Once again, Tim, that's criminal threatening versus civil aspect.
oh, sorry, yeah, no, I didn't appreciate that.
It does seem to be standard language. I also pulled up the chapter on assault and it has the same, the person who does this shall. I think it might just be the language we use.
let's look up Title 23. Remember that one? Yeah, that's the one that's
Used quite often.
Yeah, and here's in the statute around burning of a cross, any person or persons found to have violated shall be subject to ships. I'm literally just picking random crimes.
So it's burning across criminal or is it civil?
Let me find out. Sorry, I jumped off there. Burning of a cross is. Well, burning of a cross with the intention of terrorizing or harassing a particular person or persons is criminal. I think without that piece, it might be a violation of the First Amendment.
So, looking at other offenses against the purity of elections in Title 17, Chapter 35, numerous ones of these are strictly civil, and the language used there is shall be fined not more than $100 per offense. See, that's for signing office and receiving legal votes, for counting ballots and opening ballot boxes before a proper time. Felony is shall be fined not more than $200 or less than 20. That looks like it's similar for other civil violations here, but I can always go back to the judiciary team and ask them for, you know, if there's any else to be thinking about, something that.
There is a civil liability with the in the cross, so the burning of a cross is within the chapter on discrimination, and that does have a civil, like a private right of action like this does. And it reads exactly the same.
Didn't you say that your earlier statement this was already something that we deal with, it was just or attempting to simply codify?
So the Federal Voting Rights Act, as Tim testified, allows for some civil right of action if voting rights are violated. That is currently being challenged in the courts and may be overturned. So this would be putting those similar protections into our Vermont law should that federal law be overturned. I was just looking through other statutes for other places where we use similar language. And in the discrimination chapter, there is a civil or a personal right of action that reads very similar. It doesn't really name who holds it, who holds someone accountable. I guess would be the court. If the court said, yes, you're civilly liable for this, they would hold them accountable to it.
So will it just be fair to say on the floor, the committee reviewed the bill, we don't have any proposed changes, but that's not to speak to individual senators' support or lack of support for specific sections?
That's fine, but
I'm getting the sense that generally is concerned with some aspects of the bill.
That's a pretty good reading. All right.
So that's what unless there are any other changes, I'll just present that when we are asked on the floor. Well said. Thank you for coming in on short notice.